This video is about the doctrine of stare decisis. Stare decisis is Latin that means to stand by things already decided, or let the decision stand. Its purpose is to ensure uniform justice and continuity in court decisions. It's also what makes it possible for lawyers to give advice. Precedent refers to an early case that is authority for how your issue should be resolved. But not all authority is created equal. Mandatory authority refers to cases decided by courts that your court must follow if the facts of the cases are the same or similar enough. Persuasive authority refers to cases decided by courts that your court is not required to follow, but may choose to follow if there is no applicable mandatory authority. Knowing what is mandatory and what is merely persuasive is key to your research project. How to know this will be the focus of the rest of this video. There are two types of stare decisis, vertical and horizontal. Vertical stare decisis is about the precedential effect of decisions by a higher court. Horizontal stare decisis is about the precedential effect of courts at the same level. The best way to understand vertical stare decisis is to ask yourself, who's the boss? Think of where you work. You have a boss who tells you what to do. You don't take orders from other people, only from the boss. You may take orders from your boss's boss, but you don't take orders from some guy walking down the street. It's the same way in the courts. If you're a judge in the Superior Court and you look above you on the organizational chart, you see the Court of Appeal of California. If you look one level above that, you see the Supreme Court of California. When it comes to California state law, they are your bosses. In this context, you're going to look first to see what the Supreme Court has said. Then you're going to look to see what the Court of Appeal has said. If the Supreme Court hasn't addressed the issue, you do what the Court of Appeal says to do. Sometimes the Supreme Court has given some guidance, but to flesh it out, you have to see what the Court of Appeal has said. These courts are the mandatory authority. You must follow them. You might find an interesting case from Nevada, but it's not your boss. Its decisions are merely persuasive authority, which you might choose to follow if neither of your bosses have anything to say about the issue. Now, what about if it's an issue of federal law before a California court? Well, when a state court decides federal law, the only mandatory authority is the U.S. Supreme Court. The decisions of every other court, including the California Supreme Court and the federal circuit courts, are merely persuasive. A Superior Court judge might give a little more weight to the decisions of the Ninth Circuit, because that's the circuit the California district courts are in, but it's still merely persuasive. If the court finds a reasoning of a different circuit more persuasive, it can choose to follow that circuit as long as SCOTUS hasn't decided the issue. Now let's look at the federal courts, deciding issues of federal law. A judge on the U.S. District Court for the Central District of California has to ask herself the same question, who's the boss? When she looks up, she sees the Ninth Circuit looking back at her, and above it, SCOTUS. They are her bosses. If SCOTUS hasn't resolved the issue, or if SCOTUS's decision needs fleshing out, she is going to look at the Ninth Circuit for mandatory authority. The decisions of all their courts, including the other circuits, are merely persuasive authority, and she can choose to follow them only if her bosses haven't spoken. What about if a federal court is deciding an issue of California law? If that judge is trying to decide an issue of California state law, say in a diversity of citizenship case, she is going to look to the highest California state court that has decided the issue for the mandatory authority. That could be the Supreme Court of California, the Court of Appeal of California, and rarely it could even be the Superior Court of California. But whatever the highest court of California has said on the issue is the mandatory authority. Now let's talk about horizontal stare decisis. The question here is not who is the boss, but do we have to be consistent? Remember, this is about cases decided by the same court. So, does a court have to be consistent with its own earlier decisions? The courts of last resort don't have to be consistent with their earlier decisions. They can decide they were wrong before, or that times have changed and a new approach needs to be taken. For example, you may remember studying Plessy versus Ferguson, in which the Supreme Court ruled that separate but equal was constitutional. In other words, it allowed segregation. In the 1950s, the Supreme Court heard another case about segregation called Brown versus the Board of Education, and it decided that it had been wrong in Plessy versus Ferguson, and so it changed its mind and it overruled Plessy. In the past, this hasn't happened a lot, but recently the Supreme Court has started overruling long-established cases with abandon, so we will have to keep our eyes peeled for changes. The circuits of the U.S. Court of Appeals are a little different. Each circuit can go its own way no matter what the other circuits have done. However, within a circuit, they are expected to be consistent unless they overrule their own previous decision in what is called an en banc ruling. The California Court of Appeal has no horizontal stare decisis even in the same district. They never have to be consistent with themselves. Finally, some thoughts about terminology you should know. First is the difference between overruled and reversed. A lot of people use these terms interchangeably, but they actually do mean different things. Reverse refers to when a court reverses a lower court. Overruled is when a court changes a previous decision of its own, just like it did in Brown versus the Board of Education. The other thing you should be familiar with is called circuit splits. You remember I mentioned that the federal circuits did not have to be consistent among themselves. They had to be consistent internally in each circuit, but the Fourth Circuit could have a different opinion than the Fifth Circuit and a different opinion than the Ninth Circuit and so forth. When that happens, this is called a circuit split, and it increases the odds that the Supreme Court will hear a case in order to resolve the circuit split. Your next video will be what you will and won't find in the law library.